Welcome everyone. Go ahead and subscribe to the channel if you haven't already. So today, Martell Holt from Love and Marriage Huntsville decided to take to his Instagram and notify everyone that the protection order that was being sought by his ex-wife, Melody Shari, has now been dismissed. These two have been divorced since December of 2020, but always find themselves back in court for one reason or another. For all we, the public, knew that the two were just moving forward and successfully co-parenting. Well, that was until around about June 3rd. Melody posted on her Instagram a series of cryptic messages stating that she was fighting for her life for the past few days, and even that she was speaking with her kids about possibly leaving them and them having to find her when they're older. Of course, the blogs blew up. A lot of people covered the story. It wasn't enough information for me because Martell wasn't saying anything, and Mel was being very selective of the information she was releasing. However, through the bits and pieces that was being released by bloggers and even Mel, it seemed that the drama had started back up, and she claimed that Martell went out and pressed charges against her for DV, and she had an active warrant. She went on to tell us that he brought the police to her house hoping to get her arrested. However, he ended up in handcuffs and he had a protection order against him. And so that was the protection order that was dismissed on Friday. So Mel gave us a brief explanation of what she felt like happened, and she stated that she believed him pressing charges on her was in retaliation for her filing for the garnishment. Mel and her attorneys filed to garnish Martell wages, apparently for attorney fees. As far as the garnishment that was levied against Martell Holt, that has been satisfied as of May the 11th. And that document is on the screen, and we can see that it was electronically filed on May the 11th, 2026 in the Circuit Court of Madison County, Alabama, and it says motion to enter satisfaction of judgment and garnishment release. Comes now the petitioner, Kentisha M. Matthews, attorney at law, and hereby request that the garnishment issued in this matter has been satisfied and paid in full. Petitioner requests that the garnishee, Martell Holt, be released from the process of garnishment. Petitioner requests that the garnishment be canceled and the garnishee be released from further liability in connection with the garnishment. Petitioner further requests that any amount withheld by the garnishee or currently held by the clerk of the court shall be immediately refunded to the defendant/respondent, which is Martell Holt. Now, real quick, let's jump back to the order that Martell posted on his story today, which was the protection order that was dismissed. In the bottom sentence, the judge says, during the trial in this matter, the plaintiff, who is Melody, admitted an exhibit, Plaintiff's Exhibit 1, which was a court order in a previous case. And it says the court has no jurisdiction over that case. So she tried to submit a order from another case they had. I quickly wanted to speak on that because number listed DR 2020-900543.01. The order will be on the screen. This stems from a complaint that was originally filed back in 2022, but this specific document was filed March 1st, 2023, and it says order. This cause came to be heard on this date and all parties were present. Upon consideration of the testimony presented, ore tenias, the exhibit introduced into evidence, and the arguments and contentions of counsel, the court finds the following facts. Since the inception of the current litigation, both parents at various times have demonstrated to this court an inability to co-parent and have displayed an inability to follow this court's orders. This court has had to address this behavior through staunch admonishment in open court to both parents, as well as the entry of sanction orders against the father. During the current trial, this court has found the testimony of both parents to be less than genuine. Each parent can only recall testimony in their favor, but are evasive in other respects. Regardless of the frankness of their testimony, the court acknowledges that the father has made positive strides and is placing the children's best interest first. However, the court cannot find the same for the mother. In this late stage of litigation, the mother has continued to demonstrate to this court an inability to co parent. She has blocked the father from her previous cell phone on multiple occasions and, by her own admission, blocked him for periods in excess of 1 month. Additionally, by her own admission, she acquired a new cell phone in October 2022 and has failed to give the father her phone number, a clear violation of the court's parenting clause. See paragraph 2B. The mother testified that she requires the father to contact her through her work email only. The mother further testified that she does not let her children have the cell phone that the father purchased for them during her custodial weeks of custody. Therefore, the father has no way of contacting his minor children during the mother's week of custody, unless the mother sees the father's request via her work email. More concerning to this court, the father has no way of communicating with the mother in a case of an emergency exists with the minor children. This was clearly illustrated when the father had to contact an associate to notify the mother via social media to contact the father regarding an issue with one of the party's minor children. The mother has failed to give the father the right of first refusal in violation of this court's custody schedule, see paragraph 1B. Rather than contact the father and allow him the right of first refusal, the mother has utilized at least 6 non-grandparents overnight care on at least 11 separate occasions. The guardian ad litem testified that despite the challenges presented by the parents' behavior, she believes it would be in the children's best interest to maintain status quo and to keep the joint custody arrangement. This recommendation is conditioned on the ability of the parents to co-parent and communicate with each other. Therefore, upon consideration, the court enters the following orders, which the court finds is necessary to promote the best interest of the minor children. Number 1, the parties shall continue their joint custodial agreement contained in their settlement agreement filed on March 21st, 2021. Unless mutually agreed otherwise, the parties shall exercise holiday and special occasion custody of their children as set forth in the joint custody schedule attached as Exhibit 1. The parenting clause attached as Exhibit 1 are incorporated herein by reference and are made a part of this modification order as it is set out in full. The father shall have the right of first refusal for purposes of the parties' edification. If the parties cannot agree, occasional nights with a grandparent shall be considered once per quarter. 2, the mother shall provide her contact information to the father immediately. Both parents should reference paragraph 2A of the parenting clause regarding telephone contact with the minor children. Number 3, the minor children shall not participate to be filmed for television or any other social media platform without leave of the court until the children reach the age of majority. Number 4, both parents shall enroll and complete a conflict resolution class. Number 5, both parents and the minor children shall continue therapy with the therapist. Number 6, both parents shall notify the other parent if they are traveling out of town/state with the minor children. Number 7, the guardian ad litem submitted her final bill to the court in the amount of $7,660. Number 8, all other provisions of the court previous ordered, not specifically modified herein, remain in full force and effect. Number 9, all other requested relief is denied. Number 10, cost tax as paid, done this 28th day of February 2023, and we see the circuit judge's name. So in my opinion, I think she wanted to show that Martell was not following it. And I think she possibly wanted Martell also sanctioned for these things that he's doing. So it's been mentioned in these YouTube streets that Martell will not allow his oldest 2 children to have their cell phones while they are at his house. Now you can see from what we just read that Mel kind of got in trouble in regards to that. So the judge explicitly said that no, they need to have a way to get in contact with the children and each other in case, it's an emergency. So I think that she wanted to show that Martell is not following that. And I also think another reason she wanted to admit that exhibit was to show that Martell was not following the custody schedule. And the custody schedule is on the screen. And if we look down to where it is marked for F, we see it says spring and fall breaks from school. And it goes into details about how spring breaks will be handled with the kids. And that just made me remember a live that Mel did back in March, where she mentioned that Martell had basically bailed on the kids for spring break. It was his year this year to get the kids, and though she didn't have plans, it was still an inconvenience, because what if she did have plans? So I think she wanted the court to note that he was not following the custody agreement. He was not allowing the kids to have phones, and he also didn't follow the schedule by taking them this year for spring break, even though it was his time. So y'all go ahead and check this clip out that I'm going to insert of Mel during that live where she stated this.
Somewhere. I'm not going to be here. I already have plans. Now, fortunately, I didn't. But I just wanted to see if that made a difference. You know what I'm saying? Mm-hmm. Like, does it make a difference if, it's your year for spring break? I got a flight booked, so I won't be here. Let me see. Girl, the next day that nigga still was like, Mariah, let your mom know, make sure she pick y'all up from school Friday. I was like, but what if I had plans? Because it ain't my year. What if I had plans? That's real. What if I had plans? Right. What if I was going somewhere? So you know what? I said, let me tell you something. One thing about me, baby, first of all, I'm always make a way. First of all, I'm gonna always make a way. Okay. Thank you. I'm gonna always make a way, and I'm still gonna get stuff done.
So like I stated earlier in the video, I believe it's something else going on as well. I think it's something that neither one of them are really speaking on. Just from the timeline of events, I don't know when they got a co-parent, of course, but we know Mel had to hire a security guard, and she was also not filming with Martell, before she left the show Love and Marriage Huntsville. But at some points they become cool enough to where she says, she just basically asked him like, oh, why you acting funny now? You were just speaking to me, but now you don't want to speak because you have your uncle here. And, she possibly, I guess, pulled or touched his arm, which caused him to go and file this DV warrant on her, according to her. Now, so Tell supposedly went and filed the DV warrant against her on April 28th. The satisfaction of the garnishment was May the 11th, and then she said the officers showed up to her house with Martell on May the 29th, saying that they had a warrant for her arrest, but Martell was allegedly put in handcuffs. So it's like, where exactly did they go wrong? It's all a little suspect to me, but those are just my opinions. Y'all let me know what y'all think about this down below in the comments. Don't forget to smash that like button, and I'll see y'all in the next one. Bye.